Welcome to Entry Point USA, your trusted gateway to understanding the U.S. immigration system. This channel is dedicated to breaking down and comparing different types of immigration options in the United States, including visas, green cards, work permits, family-based immigration, student pathways, and more. Immigration can be confusing and overwhelming, but our goal is to make it clear, simple, and easy to understand for everyone. Here at Entry Point USA, we compare processes, requirements, timelines, benefits, and challenges so you can make informed decisions about your future. Whether you are planning to move, study, work, or settle in the USA, this channel is designed to guide you step by step. If you find our videos helpful, don't forget to like, share, and comment your questions or experiences. Most importantly, subscribe to Entry Point USA and turn on notifications so you never miss updates that could change your immigration journey. If you're planning to file an I-130 in 2026, listen carefully. If you or someone you love is planning to file a family-based I-130 petition, January 2026 could quietly change everything. Not with loud announcements or dramatic press conferences, but with subtle policy shifts that make approvals slower, reviews stricter, and mistakes far more costly. Many families assume that once the form is filed, the hardest part is over. But under Trump-backed immigration priorities expected in early 2026, that assumption could be risky. These changes don't mean family immigration is ending, but they do mean the rules of the game may no longer be as forgiving as before. And the truth is, most people won't realize what changed until their case is delayed, questioned, or denied. In this video, I'll walk you through what's likely coming, who it affects the most, and how families can prepare before it's too late. Why January 2026 is a turning point for family-based immigration. January 2026 matters because it represents a full policy reset period under a Trump-backed administration approach. Historically, the first year of an administration is when immigration agencies like USCIS quietly rewrite internal guidance, not laws, but how officers interpret them. Family-based immigration, especially I-130 petitions, often faces early scrutiny because it's viewed as vulnerable to fraud and chain migration. Even without Congress passing new laws, processing standards can shift almost overnight. Officers may be encouraged to slow approvals, issue more requests for evidence, and rely less on benefit of the doubt decisions. This doesn't make I-130 petitions illegal or impossible, but it changes how carefully each case is examined. Families who filed years ago under more flexible standards may not recognize the system in 2026. That's why understanding the direction of these changes now is far more important than reacting later. What the I-130 petition really represents under stricter policies, at its core, the I-130 petition is supposed to be a simple request, proving a valid family relationship. But under stricter immigration enforcement philosophies, the I-130 becomes more than a form. It becomes a credibility test. Officers are no longer just asking, is this relationship legally valid? They're also asking, is this relationship believable, permanent, and compliant with immigration intent? That means marriage-based petitions, parent petitions, and even sibling cases may be reviewed through a more skeptical lens. Small inconsistencies that once passed unnoticed could now raise red flags. Evidence that used to be considered enough may now be seen as weak. The petition itself hasn't changed, but the mindset behind reviewing it has. And that shift alone can mean longer timelines, more paperwork, and higher stress for families who thought their case was straightforward. Trump-backed policy direction, slower processing, and more RFEs. One of the most noticeable changes families may experience in 2026 is slower processing combined with more requests for evidence. Trump-backed immigration strategies historically favor manual review over automation, which means fewer quick approvals and more officer discretion. When discretion increases, so does scrutiny. Officers may ask for additional proof of relationship history, shared finances, cohabitation, or long-term intent, even if similar cases were approved easily in the past. RFEs don't mean denial, but they do reset the clock and increase the risk of mistakes. A poorly answered RFE can delay a case for months or even lead to denial. For many families, this will feel frustrating and confusing, especially when no official rule change is announced. But internally, the standard for sufficient evidence may quietly rise. and preparation becomes the difference between approval and prolonged uncertainty. Who will feel these changes the most? Not every I-130 filer will be affected equally. First-time filers, couples with limited documentation, and families with complex immigration histories will likely feel these changes the most. Marriage-based petitions may face heavier questioning, especially when marriages are recent, long-distance, or cross-cultural. Petitioners with prior visa overstays, denials, or status gaps may also experience deeper background checks. Even parents and immediate relatives, traditionally considered safer categories, may see longer waits and more verification. Families who assume their case is simple are often the ones least prepared for additional scrutiny. And because these are policy-driven changes, not legal ones, many people won't realize what's happening until delays begin. The reality is that immigration doesn't become harder all at once. It becomes harder quietly, case by case. What families should be doing right now? The most important thing families can do right now is stop treating the I-130 as a basic formality. Filing earlier, preparing stronger documentation, and understanding the direction of policy matters more than ever. Evidence should tell a clear story, not just meet minimum requirements. Financial sponsorship details, relationship timelines, and consistency across forms are critical. Families should also stay informed through official USCIS updates rather than social media panic. While not every case requires a lawyer, legal guidance becomes especially important for complex situations or prior immigration issues. The goal isn't fear, it's readiness. Immigration systems reward preparation, not hope. And as January 2026 approaches, families who understand the landscape will always be in a stronger position than those who assume the process hasn't changed. Thank you for watching Entry Point USA, where we compare and explain U.S. immigration pathways to help you choose the right entry point for your goals. We hope this video gave you valuable insights and helped you better understand the differences between immigration options in the United States. Your support helps this channel grow and continue delivering accurate, easy-to-understand immigration content. If you enjoyed this video or learned something new, please like it and share it with friends or family who may benefit. We would also love to hear from you, so comment below with your questions, suggestions, or topics you want us to compare next. Don't forget to subscribe to Entry Point USA and enable notifications so you stay updated with the latest immigration comparisons, news, and guidance. Remember, the right information is the first and most important entry point to your U.S. immigration journey.